committee, do you remember who, or Art, maybe you remember who was assigned judicial review? Does anyone want to claim it as the one you were assigned?
Mr. Chairman, you are live on YouTube.
Oh, thank you. Well,
Mr. Chairman, off the top of my head, I do not remember.
Okay. All right, we'll figure it out. No big deal. Committee, welcome, public welcome to the first meeting of committee number 1, Judiciary, while we are virtually in session at your Capitol and remotely where we may be. Today, we're going to consider 2 pieces of legislation. The first, a little backwards in the way that it may appear online. If you're online and you're looking to see what our business is, we're going to take them up in the reverse order of what I think they're posted online. The first bill we'll take up today will be Senate File 21, Judicial Review of Agency Actions, Permissible Venues. Excuse me. And the second action we'll take up today will be, assuming time permitted, and I assume it will, Senate File 26, Animal Abuse Statutes, Reorganization and Update. And so if you're out there and you're tuning in to view us and you're interested in testifying on Senate File 21, now would definitely be your time to get your name into the hopper and into the queue of the system so that we can be ready for you. Mrs. Creech, do you want to go ahead and call the roll?
Representative Craigo.
Present.
Representative Larson.
We didn't hear you, Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams.
Present.
Representative Washut.
Here.
Representative Yin.
Here.
Representative Zwanitzer.
Here.
Chairman Olson.
Here.
You have a quorum, Mr. Chairman.
Thank you, Danielle. Okay, committee. So before we went live, we started to discuss where this bill, we had pre-assigned some folks to this bill. So let me take a look at my notes so we can figure out exactly where we're at. This is a bill from the interim, from the old committee. So maybe Representative Washut, do you want to give us a brief introduction of the bill if you recall from the interim?
Give me one moment. Pull up some
Sure.
notes.
Sure. Yeah. And while you're doing that, Danielle, I'm assuming there's no senator that elected to come over and give us any information since it is an interim bill. That's common. Just could you confirm that for me?
That's correct, Mr. Chairman.
Okay.
Thank you, Mr. Chairman. Committee members, we're looking
Please.
today at Senate File 21, and the matter before us came from a kind of a tragic situation where we had litigation and a client filed in his home district where the citizen lived, and ultimately the court could not hear his litigation because it wasn't in the proper venue. And so what this bill does is change the requirements for venue and allows the aggrieved party to file the action in his or her home county. And that's just kind of a brief, quick overview of what this bill's about.
Thank you, Representative Washut. So looking at the bill, it looks like we amend one statute, 16-3-114. The amendment to the language takes place on page 2, lines 4 through 6, where we add, this is the part you were speaking to, in the district court for the county in which the injury or harm for which relief is sought or occurred. I guess my question for our legal eyes here is, and as I'm just skimming this, is this a permissible choice of venue, that it adds the choice of venue in the county in which the injury or harm occurred, or does it require that the venue be in the place where the injury is occurred? Maybe I don't know if Representative Crago or Representative Oakley, you want to weigh in? Representative Zwanitzer.
Go ahead, Representative Craig. I guess. Sorry.
Representative Crago.
Mr. Chairman, just looking at it, I think we have a laundry list of options for venue, and this is just an additional one. And this one's a little different than the residence one. This is where the injury actually occurred. And so the residency one's further down. I want to say it's, I'm looking at the lines 10 through 12 is, that's your residency. And so I'm not sure of what case this is dealing with, but it's probably a situation where the injury did not occur in your home county. It occurred in some other county. And so it fell into this weird area where you'd have to bring it in your home county when actually you should be bringing it in the county where the injury actually occurred, I guess. That's how I'm reading it, based on the explanation. I believe that's the problem or the gap we're trying to fill.
Thank you, Representative Crago, for clarifying that. So existing law allows you to bring the case where you may principally reside, or where your business may principally reside, or where you may take up residence as an individual. This statute clarifies that you have the ability to bring the action in the district court where the injuries occurred, kind of a similarity to substantial contacts that would allow me in a federal jurisdiction to take the case where the injury might have occurred, because that's where all the witnesses are, that's where the evidence is, likely where the evidence is, likely where most of the witnesses are, et cetera. Chairman Zwanitzer, I don't know if you have a question or if you're unmuted, so I just assume you want to talk.
I always want to talk, Mr. Chairman. Is there any public comment on the bill? I don't have access to the waiting room. But I thought Representative Crago, I was in agreement with him on the mechanics. My question, if there is any public comment, is the judicial workload. The fiscal note said indeterminable based on number of cases. I was wondering if maybe in the interim, anyone from the court system came in and had any kind of prognosis on if this would take off some of the backlog in my district court in Laramie County, because a lot of people currently file actions in Laramie County based on the state rules and regs. Didn't know if Representative Washington knew if anybody in the lobby had testified that in the summer or not, but I would hope it would cut down on cases in my county.
Thank you, Chairman Zwanitzer. Let's see if there's anyone in the lobby. Usually, and Danielle is newly to staffing our committee, and I'm new to working with her. Typically, I get an email in advance of anyone that we know of that wants to testify, unless they register late. Danielle, do we have anyone in the lobby who wants to testify on this bill?
As far as I know, Mr. Chairman, the only testimony that I'm aware of is for Senate File 26.
Okay, thank you. Will you just shoot me over an email real quick with whoever you have on that list, if it's different from what I already have for 26?
Yes, absolutely.
Thanks. And okay, so no one answered your profound question there, Chairman Zwanitzer, but we will look to Representative Washit, who's eager to attempt to answer it for us, maybe.
While he's thinking about it, Mr. Chairman, can I go ahead and move the bill?
You certainly can, if that is your pleasure. Okay. This is the part where somebody seconds it. Oh, all right, there we go. All right. So Senate File What is this? Senate File 21 has been moved and seconded, moved by Chairman Zwanitzer and seconded by Representative Crago. Any discussion on the bill, including if you want to, Representative Washut, if you have anything on that question from Chairman Zwanitzer? Representative Yen?
Thank you, Mr. Chairman. I guess Representative Washut has frozen, but I just quickly looked over the minutes from the interim, and similarly to some of the other bill drafts, this one had no public comment. So it seems that no one had anything to say about it. So I will vote for it. Thank you, Mr. Chairman.
Thank you, Representative Yen. And thank you for looking up those minutes. Very helpful. Representative Oakley.
Am I the only one that finds it, I mean, it's a fairly easy, straightforward, but yet finds the wording a little awkward? Entitled,
Yeah, I'm with you. It is a little awkward,
is
Representative Oakley.
entitled, thank you, sorry to interrupt. It is entitled to judicial review in the district court for the county in which the injury or harm for which relief is sought occurred. I don't know. I feel I get what we're trying to add here. It seems like we could maybe find a more direct way to say it.
Please, if you have an amendment.
I knew that was next. I'll have to look at it for a second.
Mr. Chairman, I just want to say I appreciate when attorneys agree that language is somewhat unnecessarily complicated. But I do think as it was a clean bill coming over an interim bill, if the wording is mostly good and we think it will hold up, it may not be worth the standing committee amendment and the concurrence with the Senate and the process if we think it's pretty close to good.
Well, yeah, thanks. Thank you. Thank you very much, Chairman Zwanitzer. So there's no, I mean, just, and you're aware of this, and just so the members of the committee are aware of this too, we don't have to pass this bill by the end of the virtual portion of our bifurcated session. Any bill can carry over into March. So, that's true of anything. We don't have to, we don't have to push it through just to get it through without a concurrence if necessary. But I think at the very least, as I look at it, it's definitely, it's more than, linguistically, it's actually very clunky now that I stare at it more. For example, just the word occurred on line 6. So it ties with injury or harm. It doesn't actually tie with for which relief is sought occurred. So, in the district court for the county in which the injury or harm occurred, just as an example, for which relief is sought. I think there's a lot of ways you could probably play with this and make it cleaner. I do think I've always struggled with this because we write statutes the way we always write statutes, and the way we always write statutes is the way we used to write statutes, and the way we used to write statutes is archaic, right? So, it's probably unnecessary to make it overly complicated when all we're trying to say is the county where an injury occurred. If it's inside of the district court, then I can go there. Seems like if there's an easier way to say it, let's say it. If there's not, then I guess we produce it out. But, so Representative Oakley, do you have an amendment? Would you propose an amendment?
I don't think I need to at this time. Thank you, Chairman. After hearing from the other good representative, if it's sufficient and it's more difficult, if we were to discuss it for which relief is sought, maybe that completely is unnecessary. I don't know, maybe I'm not thinking it through. But I mean, by filing it, that's you're seeking that relief, and then you boil it down to the county in which the injury occurred. Is that really what we're just trying to get to? And now again, that's for discussion. If it's not something that's worth doing, because of course I'm just learning, and I really appreciate the more experienced representatives pointing out, where we're at in the process. I don't quite, and then things become difficult because I don't have all that figured out. So if it's not necessary, I won't bring an amendment.
Well, and Representative Oakley, you just said what I was trying to say, but you said it much better and cleaner, which is that's what I was trying to say. It's where the injury or harm occurred, and that inserting for which relief is sought in between injury or harm occurred is confusing, and probably unnecessary. I would agree, probably unnecessary as a whole, because the entire statute doesn't have that same language next to whatever list we're part of the list we're looking at. Of course, you're going into the district court seeking relief. That's where you're seeking. That's what you're doing. You're seeking relief. I think it could just read, I agree, in the district court for the county in which the injury or harm occurred. I don't know the history of this language. If it was lifted from an existing statute somewhere else, it's very possible that it was, and that was how the language read, and that's why it's like that. I don't know, Representative Washit, you probably don't recall any discussion on where the language was lifted from. Sometimes we'll say, go look at such and such statute.
Mr. Chairman, as I recall, this case is one of those that came from the Wyoming Supreme Court, where sometimes they mention that perhaps the legislature would want to look at something. And my guess, I hesitate to guess, but I think that perhaps the language was contained in that opinion and was inserted into statute.
I will note, it's interesting that the House of Representatives is infamously known for working bills much more diligently and harder than our Senate counterparts. That's just occurs in every committee. It's a weird thing. So it's not uncommon for Senate files to get marked up. You see them, we used to refer to this as the different colored copies. We don't have physical bills in front of us. We just have the digital ones. But, there's something to be said if the Senate file returns and it's not on a different colored paper, and that means we didn't do anything to it.
If the committee pleasure, Mr. Chairman, I would like to make a motion that we delete the words for which relief is sought from line 5, and just have it read in the district court for the county in which the injury or harm occurred.
I see Representative Lorson seconding. Excellent. Discussion on the amendment. Representative Oakley.
I was going to say this earlier before the amendment was made, not that it matters, but I am already learning the danger of making those amendments, and then we find out why that was in there afterwards, because I don't know the history. I guess I can go look at that afterwards, and if we need to feel like we need to correct it, we can do it at that point.
Yeah, so I'll comment, Representative Oakley. I think the other thing you're learning in the Wyoming legislature is that everybody has an opinion about everything, and lawyers have more opinions than everybody else. And as you probably know from the world of lawyering, the opinion that you get depends on the price that you pay. So there's no right or wrong answer to any opinion that a lawyer gives you. It's just their opinion. So when you go, if you make an opinion and you go and you get another lawyer, whether that's in our chamber or the other chamber that has a different opinion, all it means is you got lawyers with different opinions, which in my experience is very common. So no worries there, Representative Oakley. Representative Washit, did you have a comment?
Thank you, Mr. Chairman. And if we pass this amendment and the bill passes the House, we'll end up having to go back with the other body and reconcile the differences in language. And if there really is an important reason why this clunky language was included, we can put the clunky language back in at that point.
Right. And I think we'll have an opportunity for, so far, we don't have anything telling us why it's here. We'll probably have that opportunity if it's necessary from some of the prior members from Judiciary. I'm sure they'll weigh in, and that might help us too on the standing committee amendment. Representative Craigo.
Thanks, Mr. Chairman. I was just going to comment that I think the reason they wrote it that way is so that it matches the rest of this, what I'm going to call laundry list below, right? It has the same tenor as all the rest of those clauses below it, and that I'm guessing that's why they did it that way.
Okay, I see what you're saying. So like if you go to the next sentence, in the district court for the county in which the administrative action or inaction was taken, or in which any real property affected. So really, if we wanted to mirror the language, we could begin the sentence with is entitled to judicial review in the county. Well, I guess it's trying to say district court. I'd probably put county. I guess my brain wants to put county first, but they seem to begin with a for which statement, I think is what you're saying.
Yes.
In the district court for the county. So this would be in the district court for the county in which we still have that injury or harm. I don't think that it continues on with which relief is sought. I really don't. I get the in which part, but I guess I'm more confused now by what your observation is. Representative Craigo.
Thanks, Mr. Chairman. I don't know why I feel this way. When I'm reading it, there's something about the language that actually makes sense to me as it's written. I mean, I understand it's clunky, but when I read it in conjunction with all the rest of the stuff, it makes sense. But I don't, from an actual application standpoint, I'm not sure it matters if we take it out.
Question?
Question?
Okay. Question being called on the amendment. No further discussion on the amendment. All those in favor of the amendment signify by raising your hand. Those opposed, raise your hand. 1, 2, 3, 4. 1, 2, 3, 4. 4 to 4. You guys are really going to leave this up to me to decide, huh? All right, I'm going to vote no. I'm just going to leave it as it is. And, but I'm going to look at this going forward, and maybe I'll just bring an amendment on the floor to delete it if we want to delete it, but I'm comfortable enough leaving it alone and trusting the good senators who cast their votes on this legislation, knowing what it said when it said it. Okay. Any other amendments or discussion on Senate File 21? Question. All right, question being called. Danielle, go ahead and roll call.
Representative Craigo.
Aye.
Representative Larson.
We didn't hear you. Still didn't hear you.
Aye.
Thank you.
We got you.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams.
Aye.
Representative Washut.
Aye.
Representative Yin.
Aye.
Representative Zwanitzer.
Aye.
Chairman Olson.
Aye.
You have 9 ayes.
Thank you. All right, the next bill for our consideration is going to be Senate File 26, Animal Abuse Statutes Reorganization and Update. Now this, good members, is a bill coming to us from Joint Agriculture. So this may be the first time that a lot of you are seeing this. What I wanted to do is bring over some of our friends from agriculture to first introduce the bill to us. The problem is there's a Senate agriculture meeting occurring right now. And I was hoping that that last bill would take us just long enough that they would be done with their business and be here for this business. I think they're still going, but we do. So we'll hold that. Just know that I'd like to hear from Senator Boner, Chairman of Senate Agriculture, if we can, when he finishes up. So I think what we'll do then is we'll move to Representative Clausen, because I'm not seeing Chairman Eklund. Is that accurate? Is he happen to be in the chamber with you there?
He's in the chamber, and I think he's watching on YouTube, but I'm not sure he can get on or not, or if he's in the room.
Do you want to just take a brief second and check with him to make sure he got an invitation, that if he wants to come over and
I certainly will
testify or needs any help,
he's watching. So,
And Mr. Chairman, he wasn't the committee chairman of Ag in the interim, so he might not have many.
Thank you. Good reminder. That's a good reminder. Thank you.
Mr. Chairman, he's going to try and get on. So,
okay.
But I was going to handle it. So,
all right. Well, we'll hang out, and if Chairman Eklund joins us, great. Let's go ahead with Representative Clausen. Why don't you, because we don't know the background of the genesis of the bill, why it came to your committee, and what exactly you were on the committee over the interim, Representative Clausen? Okay. So what exactly your committee did over the interim? Just give us a brief rundown of why it came to your committee, what you did over the interim, and how it got to where it is now.
Thank you, Mr. Chairman. So this particular piece of statute is pretty sensitive in you deal with a lot of issues that livestock, pets, criminal activity, neglect, and there's a lot of different opinions. It usually lands within the ag preview to make sure you don't do damage to the livestock industry with normal practices. And over the years, this particular piece of statute had gotten really, really herky-jerky, and our charge was simply to reorganize and update it. And there's a lot of moving pieces and a lot of parts that people over the years have had strong opinions in and put in very close details. When it went through the Senate side on the floor, there was an amendment that tended to clean up some legalese. I think the problems we've had with it, or why it ended up in your committee, is the criminal aspect of it. The portion that got amended on the floor, there was some concerns about the criminal aspect not being exactly right and matching up. I think I've worked with one of the newer members of your committee that's done an excellent job at looking at some of this stuff. And basically, there was no substantive changes. It was supposed to be a reorganization and update. And yeah, it turned out to have a little more in it. But I think we've got some pretty good fixes. And if that answers your question, or if you want to have any more discussion.
Yeah, thank you, Representative Clausen. Is herky-jerky, is that a Converse County phrase?
That's a legal term, sir, Mr. Chairman.
Representative Clausen, who brought the bill idea to agriculture? Where did it generate from?
Mr. Chairman, I think it was through Management Council. I think it was one of our charges through Management Council. And there's always been there's a lot of different so part of the criminal aspect is handled by the livestock board, part of it's handled by counties. It really has a lot of moving parts, and I think the idea was clarity, but I think there was just some over the years when things get piled on it. I think the idea was to clean it up. I don't think there was a specific instance that this necessary or circumstance. I think it was just a lot of moving parts that were difficult that hopefully, or the idea was to clean up. So,
okay. Chairman Zwanser, did you have a question or a response?
Yes, Mr. Chairman, as this is the 8th time I've attacked the statute, most of the reasons the bill is before you is from 2 years ago. You may remember at 12:45 in the morning, the Senate passed a felony animal cruelty bill, which at that point would allow a felony provision if the animal didn't die or didn't have to be euthanized. Previously in Wyoming law, the animal actually had to be euthanized or killed to get a felony conviction. We amended that law 2 years ago in the Jonah building at 12:30 in the morning, second to last bill of the session. And it passed 16 votes over the Senate. At that point, Senator Ellis helped me floor manage it. And I think the Senate realized as we were trying to explain how the logistics of the bill fit together, nobody could figure out how it worked because 6 times of amending this statute to put in domesticated animals and dog and fowl fighting, it had gotten herky-jerky is a great word, to the point where it didn't even make sense. And so I believe Management Council said the best thing we can do is just take all of these statutes and rewrite them so they're not all triple referencing each other. And that's really the impetus of the bill, was just to clean up the statute because an attorney couldn't follow it and district attorneys couldn't prosecute because it just didn't make sense.
Thank you, Chairman. I remember the day and I remember the hour on the clock, but I remember very little about what occurred during the hour. But I'm thankful that I have you to remind me what we did that fateful morning at 12:30 a.m.
We waited on the Senate to pass this bill.
Representative Lorson, did you have a question?
No. Chairman Zwanitzer took care of that very well, and he remembers a lot more than I did.
You're in the same boat I was in that morning.
Yeah. We've, in the Ag Committee, we've been discussing this for quite a few years, definitely. And hopefully we can get something done here.
Thank you. Chairman Eklund, welcome to the Judiciary Committee.
Thank you. Thank you, Mr. Chairman. Mr. Whip. Anyway, I'll just kind of add to that. Our Representative Zwanitzer has been at this for a long time. The Ag Committee has dealt with it. The fear that we have is that if you change the statute, you're likely to make it worse. A problem that we have had is that the Ag Committee is usually shorted on attorneys and people who can take a piece of legislation and chew it apart for 5 hours. But we had somebody willing to do that this weekend because they knew it was coming to judicial. So we may have some fixes, or at least a start to fix this statute that we're reorganizing. Anyway, I'll just kind of leave it there and let you continue, and I'll be on hand if you need me. I have to go to appropriations at 1:30.
Thank you, Chairman Eklund. I don't envy you going to appropriations. I spent 2 years there and did my time, and now I look forward to the day that I don't have to necessarily return. And I think we may be able to make Representative Craigo an honorary member of the Agriculture Committee to help you out over there if you need some assistance. All right, let's move to further public testimony on this bill. I see that we have, let's go ahead and I'm going to admit Mr. Otakoven, attempt to admit him. Mr. Otakoven, welcome.
Thank you, Mr. Chairman. Byron Otakoven, Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. We worked on the bill, if I may, during the interim, and I appreciate the description so far. I can understand a herky-jerky statute not quite making sense, and can appreciate the fact that we're going to clean it up, spiff it up, and spit it out so it does make a little sense. Having said that, there was a reference at one point that it was difficult to prosecute. Thus, I think most of the testimony, if I recall, in the Joint Ag Committee was from the Sheridan County Attorney, who had one of these cases that turned out to be very difficult to prosecute, and provided quite a bit of input to the statute on clarifying and as was described, the hodgepodge nature of statute A referencing statute B, which didn't result in the desired result in section C, for lack of a better way of describing that, and was able to kind of put things into perspective, and thus the statute was edited and amended, if you will, in committee to what you see today. I'm unaware of additional changes that were referenced for the weekend for additional fixes, but I did have a conversation this morning with the county attorney in Sheridan, who I believe is in your waiting room. I hope that was the goal, to provide that degree of clarity for the specific parts of where we are and what we are. But from our perspective, on the law enforcement side, we received the call first. So yes, trying to have the officer respond to the scene, try to whip out the green book, for lack of a better way of describing it, and see what the issue fits statutorily, make a call back to the county attorney's office, describe the issue, and then you end up having a consult to boot to try to figure out which section of the statute it might fit, is a little on the difficult side. So the cleanup of the statute would be greatly appreciated from that initial call perspective of attempting to sort out where some of these things happen. The second piece, and I'm sure you'll hear about later, is the piece involving the, okay, this is serious. We have the animal. We know where the animal is, but the owner is not taking care. So we're at that point of cruelty. We're to the point of care and feeding. Who's going to do that? Oh, wait, the owner's not. Therefore, either the state or the agency steps in and says, we will. But then who pays? Who does that? There's not a bottomless pit at the county or the state to be able to do that. And the statute contemplates that the owner will eventually. After all, it was their responsibility in the first place. It's their responsibility in the long run to pay for that care and upkeep while we're proceeding through the process. And there's been some question on that and how that may work. And I believe the county attorney will be able to help address that. And I'm hoping that the director of the livestock board is in your waiting room as well to help answer some of those kinds of questions procedurally. So we are in support of the statute, in part in support of the clarity that it provides. And we're anxious that it provides the clarity to both the livestock board and to the county attorney's office so that the cases can be properly adjudicated and everything goes about and as it should be, Mr. Chairman.
Thank you, Mr. Odekoven. And we do have both the Sheridan County Prosecutor's Office and the Livestock Board testimony available, so we'll get to that. And just to your point on the amendment, I'm going to do something a little unusual in the process. When we get to the, because we actually have several amendments. When we get to the amendment process, after we do that, I'm actually going to come back to you, Mr. Odekoven, and have you weigh in on the amendment. And just the way that the process unfolded, as you pointed out, you haven't seen the amendment, and I would like to hear from all the different stakeholders on any amendments that we do have. And we've got some newer members to the committee, and so the process is new to a lot of folks. And so, in the future, I would encourage anyone with amendments, especially something substantive, to try to get those to the various stakeholders as you learn who all the stakeholders are on a bill. It's always easier if we can get input from stakeholders before. Sometimes you can't. Sometimes you don't know who the stakeholders are. But it makes the process a little smoother, so I don't have to reopen public comment once the bill's been moved, which I prefer not to do. But I'm going to do it today to get your opinion on the amendment, Mr. Odekoven.
Well, thank you, Mr. Chairman. I appreciate that. I've worked with you before on several bills and understand the complexity that goes into the process for that degree of clarity, especially in the Judiciary Committee, that we crave, so that when it hits the floor, it's a good, clean, final product 90% of the time. So I appreciate that. And for the new members of the committee, especially, and for a couple of members I haven't worked with much, would it be appropriate to talk about part of how I came to represent the sheriffs and chiefs and why I seem to spend a whole lot of time in judiciary, or or shall we do that on another day?
No, I think that's appropriate since my committee is virtually entirely brand new with the exception of Representative Zwanitzer, Chairman, who's worked with you, and Representative Washit has been on the Judiciary. Why don't you briefly introduce in yourself and your association, and then when you're all done, why don't you if you have some time, send an email with your contact information to all the members so they can work with you in the future on anything that we do have, Mr. Odakoven.
Thank you, Mr. Chairman. So in terms of a background introduction, my law enforcement career started with the city of Gillette. And for purposes of this discussion, I was the animal control officer. So I dealt with these cases specifically for nearly my first 2 years of my career, on with the police department to have a trained canine working nights, street, narcotics, patrol activities through the police department, training officer, patrol sergeant, patrol lieutenant, the commander of the uniformed officers for the city of Gillette. And for 16 years, or ran for sheriff, if you will, Campbell County Sheriff in 1987 through 2003. So 16 years as the sheriff for Campbell County, and shortly after leaving the sheriff's office became the executive director of the Joint Association of Sheriffs and Chiefs. So we represent about 65 police chiefs, 23 sheriffs in our association. We take pride in the fact that we are a resource to the legislature, to the state. In fact, participate in several state grants. The governor has appointed us to several committees and task forces to be able to provide that law enforcement perspective on the issues of the day and the matters that we have to discuss. So worked with the legislature since 2003 on every session, most every judiciary meeting, Mr. Chairman. Have been there for, and do our best to, our goal at the end of the day when it comes to the statutes, from my perspective, as representing the law enforcement, is can my officer at 3 a.m. whip open the statute book and make sense out of what he sees before him as the event that's there and correlate it to the statute correctly without having to call the county attorney, the judge, and everybody just to get guidance on where to proceed. Does it make sense? And if it does, then I say job well done during the daylight, so it makes sense after dark, as we deal with many of the critical situations that we arise in our community. So with that, Mr. Chairman, that's a laudable goal, and appreciate you taking a moment to allow me to do that, because I'll generally be in judiciary every day, I sense, because I often say, a legislator says when they come to Cheyenne, there ought to be a law. That usually means we call law enforcement to do something to somebody. So it has a nexus to us, and thus we want to make sure we do it well, Mr. Chairman.
Appreciate that, Mr. Odakoven. And yet, committee, you'll get used to the familiar faces that we seek on probably 90% of the bills that we do look at. Obviously, Mr. Odakoven and his association is generally one of those, especially when we're dealing with the criminal law. And so it's not uncommon. It's not uncommon to see him in the Judiciary Committee, and it would not be uncommon for you to reach out to him or his association if you had questions about a particular bill, their opinions on it, or amendments, etc. And so with that, do we have any questions for Mr. Odakoven? I'm going to guess not, because you'll probably develop those once he speaks on the amendment, if he does. Okay. All right, Mr. Odakoven, just hang out.
And Mr. Chairman, are the amendments posted, or are we going to just verbally hear about them, or?
I don't know. Chairman Zwanitzer, are these amendments posted online somewhere? No?
They aren't, but I did forward them to Mr. Odakoven about 4 minutes ago.
Okay,
All three of
so so they apparently are online, but now they've been forwarded to you. So hopefully you can take a look at those while we move to some other testimony, and then that will help maybe frame any opinions you may have, and I can circle back to you. Because it sounds like we should have 3 amendments, I think, but at any rate, you got some from Chairman Zwanitzer and some from Representative Craigo. And if you could review those, I'll circle back to you.
Very good, sir. Thank you.
All right. A good prosecutor. Let's go ahead and let Miss Bennett in. Danielle's is fast. She's reading my mind. She already let her in. Miss Bennett, welcome. Please introduce yourself to the committee, and then if you have comments, please proceed.
Thank you, Mr. Chairman. I'm Diana Bennett. I'm the Sheridan County Attorney. I've been a prosecutor for about 22 years now. This animal cruelty issue has come up, not just by way of prosecution of it, but the laws have changed somewhat over the years. And I can't tell you the exact dates of all of that or years of all of that. I just was contacted this morning to testify here, and I've got a trial tomorrow, so I'm kind of, my mind's everywhere, but I can give you a little bit of a background, what I know. Years ago, as to animal cruelty cases, when law enforcement came across a case of suspected cruelty, they could seize the animal, whether it be a domestic animal or livestock, and take custody of it. And there was a provision in the law that provided the requirement for the judge to require the defendant that's charged to post a bond to take care of the animal while it's pending. And that always made sense to me, because I can tell you, and all of the time when I was on the defense and since I've been on this side, I haven't seen an animal that was seized in an animal cruelty case that didn't need to be seized. Usually animal cruelty cases, it's pretty aggravated before it comes to somebody's attention. The last horse case I had, the horse ended up dying. So it's usually imperative that the animal be taken out of the custody of the suspect at that time. And it used to provide, the law used to provide that all throughout any kind of case, including under just animal cruelty, not involving livestock, that a bond could be posted. And that's just to take care of the animal, because that animal, that the owner still owns the animal. And it's really to preserve the rights for the owner. They still own it. If they want to forfeit ownership at any time, they can do that. And then there's no need to go through all of this. They can forfeit their ownership and say, I don't want the animal anymore. I don't want to be responsible for it anymore. And if that happens, then we don't need to go through all of this anyway. But if they don't do that, the animal needs to be cared for, and that costs money. And for large animals, it costs a lot of money. Hay, feed, veterinarian care. Most of the animals at this point do need veterinarian care. And so that was done. Some years ago, I noticed, and I don't know why they did it, the statutes were changed, and it no longer provided for posting a bond in domestic animal cases. So dogs, cats, which are generally what we deal with most, there's no longer anything in the law that gives the judge the power to have the person post a bond. You might have heard some hoarding cases. I remember the animal shelter, the director in Cheyenne, she testified, some of those cases you get 100 animals in from a abuse, neglect, hoarding situation. And then the animal shelter's responsible for the care and food and veterinarian care of all of these animals while this case is pending, which could be 6 months. So they aren't equipped to do that. They're always trying to get donations. A lot of these are nonprofits, and there's no mechanism to take care of these animals financially while these cases are pending. So I don't know what was going on at the time. I don't know who changed it, but it's always been in place for livestock, as it is now. It is in place for livestock, but is not for other animals. I actually contacted our Senator Bruce Burns back in the day. He did bring a bill to the Senate, got it past the Senate, and then it died in the House to fix that and undo whatever was done, but it didn't pass. So from the prosecution's point of view, it's imperative to have this tool because some of these cases can take a while. And usually in a neglect and abuse situations, it's important to get the animal out of the custody. I think you've received paperwork that shows that especially livestock officers, they don't just willy-nilly go out and take custody of animals. You don't really have anywhere to put them. It's hard. And so they try everything
Sorry, Ms.
first.
Bennett, you said we may have received paperwork.
Well, I see that someone had a letter. I don't know. Maybe I'm the only one. I got a Wyoming Livestock Board memorandum. I got it emailed to me this morning, but I guess just summarize it. It just says, first try to talk to the owner, don't just seize the animal right away. And so, seizure is usually it's not the first thing you consider unless it's just obvious abuse. Some of our last animal cruelty case we had was somebody stabbed a dog and killed it. So, I mean, if there's that kind of situation, these kinds of, the bonds don't really, it's not a relevant situation anymore. But more often than not, it's these big cases involving a lot of animals and they're starving and they have parasites and they all need veterinarian care. And who's going to do it? These animals are evidence of a criminal offense and they need to be taken care of because they're living creatures, but they also, the fact that when they get fed and they become healthy very quickly, that's also provides evidence that the owner wasn't providing them with the care they needed. But the people that are taking care of these animals are taking upon all of the costs themselves. And that's what's hard to do. And what this does as far as the posting part is just says, hey, owner, this is your animal. You don't want to forfeit it. It's yours. It costs money to have animals. And we just want you to post some money and that will be used to take care of your animal while this case is pending. If there's extra money at the end, you get that back. It's money you would have to pay anyway. And so it's, there was due process concerns previously. And I mean, we can discuss that, but I think the purpose of all of this is to maintain the due process and the ownership rights of the suspects in these cases, but it showed these animals can still be taken care of, and as they are evidence of crimes, and some of them are misdemeanors, some of them are felonies. So that's a little bit of the history. I'm always been supportive of this. I mean, I said I went to Senator Burns myself some years ago and asked him what happened and why did it occur that we don't have the ability to do this anymore. Now we still can recover costs, or we can ask the judge to order costs. Say I prosecute somebody and I get them convicted and they owe the animal shelter or the cat rescue that we have in town, and they owe them $500 or $1,000 for the care of their animal. The judge can order that they repay that. But the reality in criminal law is that just doesn't happen very often. They don't get paid. And so whoever was taking care of their animals is out, and that's not the way it should work. The person that should be responsible is the owner of the animal, and at any time they wish to relinquish, they can just do that. But it's not asking anything of them that they weren't already supposed to be doing in the first place, and that's caring, buying food, and medical or veterinarian care for their animals. I do appreciate the work that the legislature has done as far as the felony animal cruelty. I think Wyoming was one of the later states that enacted that, and we were glad to see that. But I think that's a general summary of this. I think it's necessary to have. I don't think it's violates anybody's due process. There already has to have probable cause to believe that a crime has been committed before we ever even get in court and ask the court or ask a law enforcement officer who's probably already done it, seize these animals for the care of the animals. And this bill, as far as the bond part, is just saying, let's make this person care for their animal while this is going on. And there, as far as the part of
Ms.
the,
Bennett, Ms.
Yeah.
Bennett. I feel like maybe you're testifying on a different bill.
oh,
I feel
well
like right
then,
now you're- I
I'm
feel like
sorry,
right now- Are you testifying on Senate File 25, animal impounding proceedings?
yeah,
Yeah. So we're on Senate File 26, animal abuse statutes.
well, it's still abuse statutes. It's
Oh,
all
you're
part
just
of,
drawing them, you're just drawing a comparison between the two, or?
well, it's when we prosecute for animal abuse, the animals are seized. And I thought that was part of this because I've already testified on this when this was started previously in agriculture. So unless it's been changed that drastic, I printed off what I thought I would. It is the animal cruelty, but it's taking them into seizing them from the owner and taking care of them. And now, if you're just talking about what happens, that's what I was going to say is like livestock, as soon as being destroyed and all of those, there's all kinds of aspects of all of this too. That's why it started in agriculture, I think. But maybe like I said, I got recruited in this morning, so maybe I'm thinking the wrong thing, but this is what I was on the front end of this legislation.
Yeah, I think a lot of, absolutely, your comments are absolutely helpful. I think maybe you got both bills generating in your head at the same time. And so you're providing us, I think, testimony specific to the impounding bill, House Bill 25.
Oh yeah, that is what it is. I'm sorry. That's what I got emailed and printed off, so.
That's okay. That's okay. We appreciate your testimony on that bill. Unfortunately, we can't act on it.
Okay, well.
Do you have anything specific on the livestock, on the animal abuse statutes, the reorganization and updates, the livestock statutes?
I do have that as well. And it is like, well, as to bond, it's the same sort of question, isn't it? It's just a livestock. I guess I don't really see the big difference. What if Mr. Chairman could clarify what you're asking, I would.
I'm just asking if you have any comments specific to the bill that you would like our committee to consider.
Okay, again, what I was emailed was what I was talking about. So is this 1129-114?
Yes, that is the seizure, the livestock seizure, 1129-108 and 11. Well, I don't think there's a 113. That's why I'm confused. The only seizure
Okay,
in this
that's
bill
what I
is-
received in an email. So
Okay, maybe you're on something else, because the only seizure in this bill is 1129-108, and that's seized livestock, animals, and vehicles.
oh,
That's the
well,
only-
no, mine has nothing to do with vehicles. Well, anyways, sorry that I was confused, because I was confused as well. But
That's okay. Representative Washit, did you have a question?
Thank you, Mr. Chairman. Ms. Bennett, I appreciate you being here today, and I understand the confusion, but I was wondering, as a prosecutor, do you ever deal with these cases and the prosecution of them where in this bill, it creates a fund, or maybe that's pre-existing, a fund within the Attorney General's office that will reimburse the counties for the cost of impoundment and so forth? And I was wondering, are the offenders in these cases, are they assessed a surcharge or something that goes into that, much like we do with victims' compensation? Or is there a revenue stream, I guess is the question. How do we put money into this Attorney General's fund to reimburse the counties? My hope is that somehow the offenders will be putting some of this money forward. Do you have any detail on that?
I don't
Ms.
have.
Bennett? Do you know, Ms. Bennett?
Oh, thank you, Representative Washington. I don't know about it. I think that would be ideal. in a lot of these cases, we don't see that they're able to pay. That's just the reality. But I think that would, like the Victims Compensation Fund, I think I see that waived as much as I see that ordered because of their inability to pay. But I think that something like that makes sense, and that's in the situation as well, because it needs to come from somewhere, and it seems like the offender would be the obvious place that they should be contributing to it.
Representative Craigo?
Mr. Chairman, I was just going to chime in. I think that particular account, the language in there says it's, and I don't know if there's even any money in it. I wouldn't have a clue, but the statute itself says that you're only allowed to pull money out of there as a county attorney or any other type livestock board agency, whatever, if you first, unless you've tried to collect from the offender. And so I'm assuming it's there because you can't collect from the offender and you can't order them to pay because they don't have the money. If you could, you just get reimbursed from the offender directly by the court. They'd order that like restitution.
Thank you. Committee questions for Ms. Bennett? Questions? You get off easy, Ms. Bennett. But we do have some amendments. I don't know if those have been circulated to you, but you're welcome to stick around once the amendments come through. And if you have testimony specific to the amendments, I'll definitely take it. Just in the meantime, until I circle back to you, mute your mic and turn off your camera, if you would, please. All right, Mr. True, you're on deck. Go ahead and introduce yourself to the committee, please, and then proceed with any comments you have on Senate File 26.
Mr. Chairman, committee, thank you. I'm Steve True. I'm the director of the Wyoming Livestock Board. Just my quick comments on this bill, Senate File 26, to echo what your good members of Ag commented on. This is a reorganization of a fairly herky-jerky, hard to decipher older statute. I believe, and we've testified at Joint Ag a couple of times, that we were totally in favor of the work the committee did. Now, I'm no more of an attorney than some of the Ag committee members. So some of your legalese that you will get into is above my pay grade. But to note a couple of things, that there is another reference to 1129-114, which is an impoundment cost of care statute for livestock. And part of our pleasure with this bill is it made a more consistent process to be understood by officers and county and prosecuting attorneys of that process across the board, from the cat to the cow to whatever kind of animal may be in that case. So that's what we were in favor of. Quick bit of history on our agency and our role here. I'm 6 years into this position now, and prior to that time, there was a kind of a blend between the county local agencies and the livestock board in response to animal cruelty cases. In 2017, as part of a budget bill, 3/4 of our investigator unit was reduced, left us with one man. So at that time, Joint Ag and the Livestock Board made agreement that we no longer were the first responders to any animal abuse or cruelty cases. We train virtue of another bill that came in 19. They gave us gave some money for us to help train sheriff's officers and county agencies in that process. And we act as an advice and consult due to the fact that we had handled those cases for a long time. My senior investigator is also a former state assistant field vet, so we have an expertise there in helping those agencies and determine conditions and those sort of things. But we're not the first responders, but we do advise and offer consent or consultation. I did have quickly, Mr. Chairman, and I don't know your LSO process, your process, but I just want to notice that between this bill and 25, there's a little difference in terminology that may have been missed one time. In Senate File 25, it's called Persons of Authority who work these processes. The top line in 1129-109 still has the old language of any peace officer, agent, or officer of the board. Just a consistency thing. If the other bill comes forward, maybe you fix that on a technical basis. I'm not sure how that works. I just wanted to point that out and offer complete agreement with Mr. Odekoven. Our two folks and myself work hand in hand with the sheriff's offices and have a very good rapport and cooperation in these cases. And I certainly appreciate Ms. Bennett's testimony this summer and today, and she's been a very good clarifier of the prosecuting piece of that puzzle in these cases and how difficult those cases can be to prosecute. So with all that, I would be happy to answer any questions the committee may have.
Thank you, Mr. True. In that language you reference, any person with authority to enforce. I see that in Senate File 25.
Yeah.
Is that, I'm not familiar with these statutes. Is that also language in our existing statutes? Or do you know?
Mr. Chairman, it is not. That was a change that was made when Ag Committee worked the bill. But they're following the definitions of that county peace officer agent. It's only law enforcement officers or my two investigators who are the only two who meet that designation of certified peace officer. So, and that can be in conjunction with the state veterinarian's office, which is part of our training, that nothing's ever done without consult with a vet, be it a practicing veterinarian. And a lot of times our vets may be the backup consultation to that.
Okay, excellent. Well, we'll definitely take a look at that when we dive into the bill. I've made a note I can't remember what's in the amendments and not in the amendments at this point. So I made a note, but you go ahead and make a note as well. And committee, do you have any questions at this point for Mr. True? No? All right. Well, Mr. True, I'll say the same thing I've said to the other participants, and that's since we do have some substantive amendments, those are brought and made. I would like you to be able to weigh in on them, just the same as Mr. Odekoven and the good prosecutor. So if you want to just hang around, you don't have to exit. It's easier if you just mute and turn off your camera, and then I'll circle back around to you to make sure that we get your opinion on anything we try to do, so we don't monkey anything up or make it more herky jerky, which if someone can get those words in that phrase amended into the bill, I'll be very pleased with this committee.
Mr. Chairman, thank you. And Representative Crago, thank you for sending me the amendments. I haven't had a chance to wrestle through them yet. And Mr. Chairman, I am sending Danielle the documents that Ms. Bennett referenced. Those were sent to the Senate in reference to 25, but okay. That will wind up in your committee as well if it crosses chamber. So you just as well have those. Okay, that would be helpful. Danielle, I appreciate Danielle following up with you on that, and that may help some of the members, I think, too, with understanding the two bills as they run side by side. Thank you. Okay, very good. Thank you, Mr. True. Committee, what is your pleasure?
Move the bill, Mr. Chairman.
Bill's been moved by Chairman Zwanser, seconded by Vice Chairman Washit. Discussion on the bill, amendments on the bill. So what I'll do is, let's do this, since I know I've got some amendments. Chairman Zwanser, do you have a preference on the order in which we take these amendments?
Thank you, Mr. Chairman. My preference would be to do Representative Crago's first, either of his amendments. His first one that he sent out ties, mine will fit in either way, but I kind of want to know if his is going to pass before I offer mine, because there is an inconsistency right now on, animal cruelty, aggravated cruelty, and felony cruelty. So we should probably have that discussion first and go from there, if that's okay with you and Representative Crago. Yep,
I appreciate that, Chairman Zwanser. I'm tracking with you 100%. Representative Craigo, let's take your amendments one by one, and let's start with the first amendment that clarifies aggravated, I believe it removes aggravated animal cruelty, clarifying the misdemeanor felony distinction.
Thank you, Mr. Chairman. I'd move my first amendment, which I emailed everybody earlier. And just, I think what I'm trying to do with this amendment is clean up this distinction between aggravated animal cruelty.
Hold on, Representative Craigo. Let's get the process down. So you move the amendment, got a second on the amendment, seconded by Chairman Zwanser. Thank you. Discussion, Representative Craigo. Now please explain your amendment.
Thank you. And I apologize for my newbie ignorance.
That's
I'll get
all right.
better, I promise.
You're doing fine. Go ahead.
So what I'm trying to do with the amendment is clean up this aggravated animal cruelty distinction that's contained within the statute, because there really isn't, it's what we would say a distinction without a difference, because in actuality, under the current statute, aggravated animal cruelty has the same penalties as the animal cruelty. They're both misdemeanors, and typically aggravated denotes a felony type crime. And so we get rid of that language, and the amendment slides all of the, essentially gets rid of section 1003 under the bill and slides all of the penalties, or excuse me, all of the descriptors of what a crime is into one section. Now, that being said, the reason originally, I'm guessing, the reason aggravated was delineated out was because it could be a felony if the animal died as a result of those actions. And so what we did was, in what I've done in the draft amendment, is still allow those 5 different actions to constitute a felony if the animal dies or has to be euthanized as a result of those actions. And so the criminal aspect, or the penalty aspect, I should say, remains exactly the same under my amendment. It just gets rid of the word aggravated. And it also then will be in line with what the Senate did last week down the hall, which was to remove the penalties for aggravated. We're going to keep those in there. We will keep those in there, but it'll be reorganized, I guess, is the best way to describe that.
Thank you, Representative Craigo. So I want to clarify that your amendment does not create a new felony.
It does not.
And your amendment does not create a new misdemeanor.
It does not.
Chairman Zwanser.
Thanks, Mr. Chairman. Just quick background. So way back 15, 20 years ago, and actually still in Game and Fish, we used to have classes of felonies, and other states have various classes of felonies or misdemeanors. And so many of you remember maybe a decade ago, in Baltimore, or a certain famous football player, I guess we can say names, his name was Michael Vick, in committee, had a big dog. And so there's a push nationwide to make sure every state had a felony law in the books for dog fighting and fowl fighting. And so Wyoming settled on this weird aggravated or enhanced type penalty for aggravated animal cruelty when it came to dog fighting. That was 10 years ago. We've modified the statute 3 times. The Senate took this out. And so now it is, it took me a while to track it all, but it is a little murky. And so I like what Representative Craigo is doing after it took me a bit. And overall, at least from my background, the desire has always been to allow enough statutory construction to have a prosecutor actually go prosecute one of these crimes. Lots of people come out of the woodwork when an animal abuse case happens, who write you as a legislator in the newspaper, and it's a big deal. People take this stuff really seriously on animal cruelty. And so my overall thing, and why I brought my amendment coming forth, is to allow enough of a punishment that a DA or a county attorney will in fact go after some of these egregious cases. So I'm fine with Representative Craigo's amendment. If we take out aggravated, and just my hope would be, I guess I'm going to advocate for my next amendment, that we do allow a wider variety of punishment or a possibility if we take out that middle aggravated charge.
Thank you, Chairman Zwanitzer. There questions for the bringer of the amendment or discussion on the amendment?
Mr. Otokoven has his hand up.
Oh, does he? Okay. Yeah, I'll go ahead and open up public comment. Mr. Otokoven, discussion on the amendment.
Thank you, Mr. Chairman. And I did do a quick email to Representative Crago with my question. If we're on, and to verify, we are on amendment number 1 of the
Correct.
Crago amendment.
Yep.
So if I read that correctly, and please, I'm going to minimize you. So if I do something, holler at me. It appears in line 1 of the amendment number 1, we delete 6.3.10.10. If we scroll to the bottom of the bill, 6.3.10.10, unless I missed it, are we now eliminating the state statute covering household pet protection account, or are we merely eliminating it from the bill? Mr. Chairman.
Representative Crago.
Thank you, Mr. Chairman. We're just renumbering that statute. We are not removing it. So it becomes, if we look at the proposed amendment on number 1, page 1, line 9, it just take out 1010 and replace it with 1009.
Mr. Chairman, I thought that was the case, but just the way it was worded, I just wanted to verify that it was not somehow doing what I suggested. So thank you, Mr. Chairman. Other than that, based on the discussion, I think the amendment tracks well. And thank you for the indulgence.
Thank you, Mr. Otokoven. Representative Lorson, Dan.
Yes, Mr. Chairman, thank you. Can you hear me? I hope. Maybe, I don't know.
We can.
Yo, okay. In our original working in this through the Ag Committee, the felony cruelty to animal penalty only applied to the aggravated cruelty when they're when the animals are fighting and something died, I think. But I don't think it included just cruelty to animal. And I was wondering if that's combined now, or just, are we still, I'm just questioning that. Thank you.
No, that's a good question. That's kind of where I was going with my initial questions. Representative Crago, will you clarify what the felony is versus what the misdemeanor is?
Thank you, Mr. Chairman. I did not, so the amendment does not change that part of the draft bill from joint ag. It changes the nomenclature of the referring numbers, but it does not change what constitutes a felony at all. It's the same actions would constitute a felony.
Excellent. Chairman Zwanitzer, did you have something to weigh in on that?
Thank you, Mr. Chairman. I would agree with that. And then my concern is that in some way can weaken the current law, which is why I have an amendment forthcoming. But you'll see that it makes that distinction when you have a repeated act as well in the bill of when that can turn into closer to a felony versus standard misdemeanor if they commit a similar action within 5 years.
Very good. Other questions or comments on the amendment? Seeing none and sensing your urgency to vote, and hearing the call of the question, all those in favor of the amendment signify by raising your hand. And those opposed, amendment passes. Representative Crago, your second amendment, please.
Thank you, Mr. Chairman. So my second amendment really deals with when we converted all the statutes, when joint ag converted all the current statutes over to this bill, there was some rewording done as part of that process to make it all fit because of the reorganization. And so I guess I went through the proposed bill and looked at all of the places where I think the language needed to be adjusted by a word here, a word there. And I'll be honest, I was probably really looking at it from my ag background, my ag perspective as I was doing that. But the more I thought about it, it probably applies to a lot of the household pets, dogs, cats situation as well. So I would, at this point, I would move my second amendment.
Okay. Moved by Representative Craigo and then seconded by Vice Chairman Washit. Representative Craigo, do you just want to walk us through, because these are all doing little different things throughout. Do you want to walk us through one by one briefly?
Yes, Mr. Chairman, that would be great. Thank you. So the First Amendment is on page 2 of the engrossed copy, lines 4 and 5, and it gets rid of the definition of cruelty. And that particular definition was not in the old animal abuse statute. And when I went back and looked at that 61104, it's a definition of torture, torment, or cruelty. And as I read that, I think that's meant to apply more to crimes against humans. And as I read this statute, and what I think we're doing is defining what cruelty to animals is within this bill itself. And so I think it confuses the situation, because as a prosecutor, do we have to go look up the definition of cruelty and then play that into these other actions? And I would submit that we should not have to do that, that cruelty to animals is actually defined in all these actions. These actions could constitute cruelty to animals, and we don't need that definition within the statute, this particular statute. We need it elsewhere, I'm sure, but not probably here. So that's my first proposed amendment within the amendment. The second one is on page 3, line 14 and line 15. And what I'm proposing here is that we move the word unnecessarily from line 15 up to line 14 and put it right before injures and right after knowingly. And the reason I'm suggesting we do this is I believe unnecessarily should be a qualifier or an adjective for injures and beats. And the reason I say that is, again, I'm thinking about this probably from an ag perspective. There are certain practices we do in the field, whether it be branding or whatnot, that maybe we do it knowingly, but it's necessary for our line of business. And so, and this is one of the big changes from the old statute. And so I think that, that qualifier of unnecessarily should apply equally to injures and equally to beats. So, and for it to be a crime, you'd have to intentionally or knowingly, either one's fine, unnecessarily injure or beat an animal. And intentionally wasn't in the old statute. Knowingly was, or the current statute, I should say. I keep saying old, but in the current statute, it wasn't there. But I think it's fine if it is. Probably good that it is. And so you'd have to prove either intentionally or knowingly and unnecessarily injures or beats an animal. The next one that I have on the proposed amendment is on page 5, lines 8 and 9. And so I had concern with the way this was written. And I sent an email to maybe some of you because I said, if a dog, say I have 2 dogs in my backyard and they are fighting and I'm knowingly permitting that, I guess, just by being there, is that a misdemeanor? Or if my wife's 2 chickens get into a fight, and obviously we have prosecutorial discretion in this state, but I just thought we should clean that up. And under the old or the current statute, it just said essentially the language is, it says permits any actions under, and it refers back to essentially for sport, the subparts above that, and it says allows anything prohibited by sections 1, 2, and in this case 4 to occur on your property. And so what we did here is just change it back to the old version of the statute, so that if you're allowing dog fighting for gain, for instance, if you're allowing dog fighting or fowl fighting for sport on your property, you've committed a crime. And it's a misdemeanor to begin with, and it can escalate to a felony, depending on if an animal dies or it has to be euthanized as part of that. So I just think that's cleaner and clearer, and it takes any guesswork out of what constitutes a crime for allowing that sort of activity on your property. Getting to the next one, I got to turn a few pages. So the next one is on page 10 of the engrossed copy, lines 5, 6, and 7, which is the rodeo exception under the statute. So under the current statute, the exception is it just says rodeo events, whether the event is performed in rodeo fair, jackpot, agricultural exhibition, or other similar event. And as I read the current statute, it would protect the people putting on the rodeo, the stock contractors, anybody, the people who, for instance, did protect Shine Frontier Days. Let's take, that for example. The way it's written in the bill draft, I think it takes the protection away from the people who are putting on the rodeo, hosting the rodeo, the stock contractors, the place where the rodeo is located. And so my proposed amendment, which would read rodeo events, training for rodeo events, or participating in rodeo events, would be essentially exempt under the statute from animal cruelty crime. And I just think it covers everybody that way because, like I said, I'm afraid now the way it's written, it would only cover the people who are actually participating in the rodeo, not those hosting it or otherwise being involved. Amendment 5, which is down further on page 10, and it's just a one-word inclusion. Line 20, so we would include the word pest, and this was a request from essentially Joint Ag. Several of the ag legislators wanted us to add the word pest in. So it would say the hunting, capture, killing, or destruction of any predatory animal, pest, or other wildlife, because the pest, whether it's grasshoppers or whatever, they don't fall under predatory animal in the definitions within the statutes. And so this would clean that up so that would apply too. And I think as far as the written amendment, that's all. I have one other thing at some point that I want to discuss with the committee, but we may not get to that right away. But that's amendment number 2.
Okay, yep, let's take it up as we go. So the rest of that, page 14 and page 15, is just dealing with the changes that we made. Okay, so nothing substantive in the last few lines. Okay, committee discussion on the amendment. Representative Lorson.
Thank you, Mr. Chairman. I have a question on his proposal on page 5, dealing with I guess it's page 10, I'm sorry, dealing with the rodeo part. Do you think we're still including, the fair events and that sort of thing, the jackpot and agricultural exhibition in rodeo?
Representative Craigo.
Mr. Chairman, sorry, I did not do a very good job of explaining that. Representative Larson, I did not take that part out. That part remains in the bill draft. Sorry, my fault.
Chairman Zwollen, sir.
Thanks, Mr. Chairman. And I'm going to have a question, just some background for the committee. Before they put intentionally in the new bill, it used to be like unnecessarily beating or knowingly unnecessarily. And that was for weird reasons, like if you put a shock collar on a dog. We had like 5 or 6 instances where you would harm an animal for its own long-term protection. And so when the committee fixed that in the interim, I think Representative Craig goes right to do that. The pest thing, otherwhere in the statutes, you can already exterminate pests. In this case, I think it's just ground squirrels and prairie dogs would fall under pests that aren't, unless you're really going to go cruelly injure some grasshoppers or locusts, which is fine. It's covered elsewhere in statute, but I'm sure it's okay to put in here. But my question then is on the rodeo events. So right now, the law is kind of more specific if you're participating, let's say, steer roping, those type of things, calf roping. The way he explained it, now I'm kind of worried, is if you are going to conduct a rodeo and you're bringing in calves and you're storing them for a day or two, and if they're not providing them proper care and food and water, those type of things, are they still liable, or are we giving a blanket exemption? If you say you're about to hold a rodeo and you're inviting your 10 friends over tomorrow to, come rope some calves or whatever it is that a way around the law of animal cruelty? And I guess if I just have some comments from Representative Crago on that, if this is too broad of an exemption and people can have some blanket immunity, in some cases they shouldn't.
Representative Crago, can I have a rodeo in my backyard in order to abuse animals?
I would say not. Here's what I would say. Under the current law, if that's true, then under the current law you can do it right now. And so I would hope that we, and I hadn't thought about that, so it's a great question, but I would hope that some of the other provisions within the statute would prevent that. I mean, we're still prohibited, whether it's livestock or otherwise, from not feeding our animals. I mean, there's other parts, in Title 11 that I would say specifically applies to that. Maybe not necessarily right here, but I guess I wouldn't be worried about that, but I'm definitely willing to work with Representative Zwanitzer to look at that to make sure we don't have an issue there, because that's not my intention, nor pretty sure, nor the bill draft in front of us. So.
Okay. Representative Oakley.
Thank you, Mr. Chair. I have a question. So heaven forbid we do this again, but are you just saying to add unnecessarily and leave knowingly? So we have intentionally or knowingly, unnecessarily injures, or, I mean, at that point, can't we get rid of the knowingly? Which you wanted to do last time. I'm not sure that there's a clarifying point to it at that. Do you have to knowingly do something unnecessarily? What does that get us?
Well, Representative Crago, you want to take a stab at that?
I do. Thank you, Mr. Chairman. So that's the language in the current statute, actually, is knowingly, unnecessarily. So you have to show both. And so I would say, actually, I know I lobbied against the knowingly the last time we had this discussion somewhere else, but I would say in this particular instance, there's not two of those, right? Knowingly and unnecessarily are not the same things, and I guess that's where my argument's a little bit different than the last time we talked about the word. So we are saying knowingly and necessarily, or intentionally and unnecessarily. You have to show both those things.
Yeah, I think this particular Romanet 2 is a little tricky because it's got two ors in the middle of a sentence. So it's got a couple of different standards that you could look to, or elements rather, I guess, because you could say, okay, intentionally, unnecessarily beats an animal, knowingly injures, or unnecessarily beats an animal. So you get three different things you can be looking at. And I think if I understand this amendment right, all it's trying to do is say that do we want the standard to be knowingly injures or knowingly unnecessarily injures, as opposed to just knowingly injures? Unnecessarily becomes the true qualifier, because I think knowingly remains that you knew, whether it becomes superfluous or not. I think that's a good question, Representative Oakley, but I track where this is coming from, because I could know about the injury and it could be intentional, but it could be a necessary injury. And I'm not an ag guy, I'm a city boy, but I think of that from the ag perspective, where I have animals that some may consider it, well, it's an injury, And the question of whether I did it knowingly isn't really a question anymore. I knew that I did it. The question is whether it was necessary for me to cause that injury to my animal, i.e. branding or, castrating or whatever it may be that I may do. The question, I think, is whether it's necessary. So at least that's how I read that qualifier. But I would love to have another debate on the floor about knowingly for whether even if you pass this amendment, I think you still have the debate. It's just a different word called unnecessarily.
May I speak? I completely get the unnecessarily. I think it's key. I think it's the whole point. I think throwing in knowingly in front of it doesn't help a darn thing, but I'm just not going to argue it again. But I mean, the unnecessarily is absolutely key as this discussion, which seems to be a lot that and we don't want to criminalize something that is something that, again, whether it's in food production that we do all the time, branding, roping, all that stuff. I will throw out that it never seems to be discussed. And again, I don't want to criminalize it, but does anybody have a single example of prosecutors like really, going out to ropings to prosecute for animal cruelty? Like, we need to get it right. But the reality is the statute is to get right the criminality of people who unnecessarily torture and are cruel to animals. And we all really know what it is. And it isn't easy to get the words right, but the focus isn't so much on, I wouldn't say, is focusing on getting right what we know to be criminal. Because I promise you, we've discussed them being difficult. We have cases, I've prosecuted many hoarding animals getting no vet care, even, sitting there enclosed and they've had a porcupine and no vet care, things like that. We all know what we're getting. And I've yet to see the wide net cast and go for egg producers. Just a thought there too. And I guess while I'm just to make sure, so the clarification on the punishment statutes is we're misdemeanor, so we've got 6 months, then up to a 2-year for a second offense. Is that where we're at with that, Representative Craigo?
Representative Craigo.
Sorry, Mr. Chairman. I am trying to get my mute button off. I did not mess with the penalty provision. That I didn't touch any of that. Neither of my amendments messed with the penalty provision. I will note that the penalty provision does change a little bit, from the current statute to the new by putting a time limit in there from unlimited look back to a 5-year look back, similar to a DUI or something like that. But other than that, I personally, neither of my amendments addressed the penalty portions of the statute. I didn't want to touch any of that.
Representative Yin, did you have a question?
Mr. Chairman, I just wanted to think of an example of something that would be unnecessary and injure an animal, but not knowingly injure an animal, and see if this falls under what the other representatives are thinking. So if I trip and fall on an animal, it's definitely an unnecessary injury, but is it an intentional or knowing injury? And so maybe I don't want to charge someone with animal cruelty if it was an accident, but I would if they purposely did such an act. That's all, Mr. Chairman.
Thank you, Representative Yin. Well, if any representative so desires to remove the word knowingly, I think the swiftest and most effective way to do that is on a co-sponsored amendment with Representative Stith, because then it would blow the minds of the body that he came and removed knowingly from a different statute. So if you really want to do it, I think that's the way you do it, because that'd be really fun. Representative Oakley.
I just would like to say that's sorry. Thank you, Mr. Chair, to speak to Representative Yins. I mean, that's a good example, and that is why we have those mens reas in there. So I'm fine keeping it. The reality is it's irrelevant, but shoving more words in when you have to show them to the jury doesn't actually help get you there. But that's the way it is. I'm fine with it personally as it is.
See, I love Representative Yin because I pretend to be a tech guru software guy, but I'm not really good at it. But when he pretends to be a lawyer, he drives it home. He may have actually gone to law school, and he's duping all of us. All right, he does it on rules. He's really good on rules. Mr. Odakoven, do you have any comments on this amendment as a whole?
Thank you, Mr. Chairman. Byron Odakoven again. At first, I was a little bit concerned, but I appreciate the discussion and understanding where the amendment's going with a couple of quick points. And I really appreciate the whole discussion on line 14, where we're trying to decide if we want to add unnecessarily or not. Because as was mentioned, we generally don't end up with county attorneys necessarily who would be charging someone and arguing in front of the judge when we find it was a bad case to start. That rarely, I mean, if ever happens. What we do end up is with the citizen coming in to complain to law enforcement and say, look what they're doing over there. This is against the law. And we whip out the statute book and go, no, it's not. And then sometimes those folks go on to the county attorney's office to say, we just got told it wasn't the case and we want to appeal that decision to you, so to speak. Having said that, clarity on line 14 is paramount to making sure those initial discussions, I get intentionally, got that one. I get knowingly, I think, and unnecessarily beats an animal. I'm still a little fuzzy on knowingly, unnecessarily, which leads to Representative Yen's discussion of knowingly, necessarily, is the counterintuitive question. So clarity for sure. Other than that, I think the amendment's certainly on track.
And Mr. Odakoven, do you feel like that page 3 line 14 adjustment by Representative Craigo makes that more clear? Or is there a different way to clarify that Romanet?
I think I could argue that it makes it more clear. It is a little funky on the language. I think if I was standing up in front of a group of officers, I think I could get my point across. And that's how I was trying to attack the idea. If I could get my point across to provide them guidance, again, at that proverbial 3 a.m, what does this deal look like? I think I could get there, subject to the county attorney correcting me, so to speak. I may have a different answer for you after I consult with the county attorney.
Okay. Always consult your attorney. All right. Mr. True, you've been listening in. I don't know if you'd like to make any comments on this amendment or any part of it.
Mr.
We should
Chairman,
welcome you.
thank you. I was kind of in the same boat as Mr. Odakoven. Can our investigators teach that in a way that's clear and easy to understand? I think so, and I would probably tie it into a rodeo analogy, seeing as that's my background, in that I may knowingly hold my rope and calves off of water, which somebody may say I'm committing abuse. However, it's necessary because I don't want them to have a full belly when I practice and take the opportunity to maybe hurt one. So I think there's analogies we can make when we train that. As to an earlier comment that Mr. Odakoven made about that officer being able to judge that in the middle of the night, now that's going to come down to education, I think. But from where our standpoint is, that language is fine, and I think these amendments are all useful.
Excellent. Thank you, Mr. True. Committee, any further discussion on the amendment?
Question.
Chairman Zwanitzer, I would like to know if, because this would be easy for us to do, if you do you think it's easier if we sever out line 29 and get rid of the page 10, line 20 pest insertion, since we already have statutes covering it, or are you comfortable just leaving it? What would you like to do?
I'm comfortable leaving it. I don't think it matters, but yeah, you can already do anything you want to a pest. If you want to mutilate it and harm it in any way, shape, or form, it's allowed. I feel kind of sad about that with prairie dogs, but if we allow that for coyotes or porcupines or skunks or feral cats, yeah, I'm not going to win that argument on prairie dogs.
Chairman Zwanitzer, everything you just said now makes sense to me in my head as my wife refers to me as a pest. Okay, the amendment's been moved. No further discussion. Amendment's been moved. All those in favor of the amendment signify by raising your hand. Okay. All those opposed, raise your hand. All right, that amendment carries. Representative Oakley.
Thank you, Mr. Chair. I have a question that's basically, it's informal. I'm sure I'm out of line here. I want to know how to proceed.
If you're out of line, I'll gavel you down.
Okay. Well, I mean out of order or something. I'm not going to insult anyone.
Go ahead, Representative Oakley.
Thank you. It's basically like a new amendment, and so I'm just wondering how I should handle that. I know, and now it's late. Maybe it's too whether I get a hold of LSO, but and I had it written down, subsection 3 on one of these. But let me just give you the idea behind it, which is it has an open-ended order for judges to be able to prohibit the use or the further ownership of animals, which I really like and I think is really important. But as it's written, we don't have either a criminal penalty attached with that, or we don't have any. And my question would be, what's the use of it, or what's the enforceability of it? Let's say somebody gets convicted of misdemeanor animal cruelty, and then they're told you can't have animals again. And then 2 years later, somebody the new law enforcement officer could say, well, this says here on this this misdemeanor JNS that you can't have animals. Well, then what? They can't be revoked on their misdemeanor. It seems to me the next step is then to have that and then have an enforcement provision, and in thinking of how do you get to that enforcement provision, I guess my suggestion at this point would be to have criminal penalties attached to that as well. So it's a lot, and I don't know if it's for right now, but I guess while I've got the group here, I thought I'd ask for any sort of input or direction on how to get there.
Well, you can Representative Oakley, you don't have to have the amendment written to make it here in committee. You can make that amendment. And if it's seconded, we can discuss it, and you don't even have to have it in technical form. If you conceptually understand your amendment and the representatives conceptually understand what you're doing and they agree with you and pass your amendment, then between now and the time that this bill goes to the committee of the whole, that standing committee amendment would be drafted. It's not as common because, if it's an easy fix, sure. If it's something that's going to have some substance to it, and it all depends on how this committee is willing to treat conceptually. If you know technically how that amendment would be written, you can certainly propose that. A side alternative for you is that you don't have to have a standing committee amendment. You can have a second reading amendment, or you can even we haven't had one of these yet for the new legislators. You can have a committee of the whole amendment too. In addition to, after standing committee amendments, you can have what's called a first reading amendment, basically committee of the whole amendment on the bill, and you can bring it right then. You don't have to wait for second or third reading. So you've got plenty of time if you want to prepare the amendment. It's just, it's up to you whether you want it to be your amendment or the committee's amendment. Go ahead, Representative Oakley.
Sorry, I'm trying to be the formal. Thank you, Mr.
I
Chair.
appreciate that.
So actually, and what I was going to get at is I see Representative Zwanitzer's hand up, and I'd kind of like, if you're willing, if you'd weigh in.
Well, actually, if you don't have a motion, I'm going to move to Chairman Zwanitzer's motion because we need to get back. So, you know, those are your paths. You can make an amendment or you can bring an amendment on the floor. Would you like to make an amendment or would you like me to move to Chairman Zwanitzer's amendment?
If I'm up, I'll move to make an amendment. Is that correct?
Yeah.
So without, I don't know how to get there. You just said I could do it without having the formal language, but I would move to amend to create a statute criminalizing ownership of animals after it's been prohibited, after a conviction of animal cruelty.
Okay. Second, do we have a second on the amendment? Second, Chairman Zwanitzer. Okay. Discussion, Chairman Zwanitzer.
Thanks, Mr. Chairman. I think the good representative would probably have on page 9 on line 5, she would want to create Romanet 4, which would tie back to the standard misdemeanor penalty given an animal cruelty. I assume she wants the same penalty. And so as that's under the section on additional remedies, that's where I'd put the punishment that would tie back into 631,006 and say anybody who knowingly violated the order. I know Kayla, our attorney, could draft that. Knowingly violated a judge's order on continued prohibitions to face that fee. I would just add that I don't believe that was ever contemplated. And so certainly surrender of the animal that was beaten. And then as we've talked about this section for a decade, that other section in Romanet 3 on line 2 on imposing continuing prohibitions was really if they owned other animals. So they beat their horse and they had some donkeys or a dog, could they have to surrender everything? But never in the discussion has been, you know, will they never be allowed to have new animals? That's something I think new from the long-term conversation, but I'm certainly fine with it. So happy to encourage that amendment. And I do believe LSO could draft it appropriately. I could call for the question too.
That seems like a friendly amendment to the amendment, Representative Oakley, or clarification to your amendment?
Thank you, Mr. Chair. Yes, I would agree.
Yep, and I think that would be the process here that, you know, Danielle's taking notes, and then I think you guys are taking notes, obviously, so you get with LSO. Between now and then, Chairman Zwanitzer and Representative Oakley to clarify exactly what it is. Danielle, are you tracking with us?
I am, Mr. Chairman. I actually was just wanting to check with you to ensure that Representative Crago's amendments include the authority for LSO to kind of harmonize those two.
Yes, absolutely.
Okay, great. And then I do have Representative Oakley's conceptual amendment as well.
Okay, thank you, Danielle. Further discussion on the amendment, Representative Provenza.
Thank you, Mr. Chairman. I just have a quick question. So I just want a clarification. So we are essentially by this amendment creating another crime, misdemeanor offense if you own an animal after a judge has said that you can't own them anymore. Is that correct?
Representative Oakley, Chairman Zwanitzer, is that your understanding of the amendment?
Thank you, Mr. Chair. Generally, yes, that's where I'm going, and we're asked about it quite a bit. You know, when we see repeat offenders, and so this gives us a way to hold repeat offenders accountable.
Vice Chairman Washington.
Thank you, Mr. Chairman. Just so I'm clear, we're talking about a judge ordering somebody that they can never, ever own another animal. and now it's going to be a crime, or is it just for the duration of their probationary period? I guess I'm a little nervous about, taking away a rancher's livelihood if they're convicted of.
Oh, Vice Chairman Washit, you froze. Chairman Zwanzer.
Thanks, Mr. Chairman. I think Representative Oakley, we have that provision in the law now on page 9. You'll see it in Romanet 3, that a judge at their discretion could put a limitation on any long-term ownership, possession, or custody of any animal. I've never heard of them using that in Wyoming. Certainly in other states they have, but that's currently allowed in the law, but there's no, as Representative Oakley points out, there's no punishment if they do without an additional statute.
Representative Oakley.
Thank you, Mr. Chair. To address the good representative, as I'll repeat, what Representative Zwanitzer just said, slow down, that it already does exist, but I think a point of clarification that's really important, it would be what a judge ordered. It's not just automatically never ever own any animal. That's it. It refers back to that it says the judge can impose continuing prohibitions or limitations on the ownership, possession, or custody. That's currently the language. So they could say you can't own an animal for 5 years. They could say you can't own any more dogs. A lot of times what we see, again, with these repeat offenders tends to be a specific thing, like they're a dog hoarder, they're a cat hoarder, they're something like that. So the point, I guess, is there's room for a judge to tailor it for the offense for which the animal cruelty offense for which they would have been convicted. And then, so if that makes any sense, it's not just never ever own any animal, it's what the judge says specific to that case.
Representative Provenza.
Thank you, Mr. Chairman. I guess my follow-up question for that would be then, what is the punishment if one is found to then own an animal that a judge has ordered that they couldn't? And how, talking about repeat offenders, I guess to the point, maybe a separate point, is how then do, with someone who's hoarding cats, that sounds like maybe some other issue that the criminal, like going to jail, wouldn't necessarily fix. It might be something that we need some other like mental health or something else to then actually fix the problem rather than incarcerate them. Thank you, Mr. Chair.
Thank you. Representative Lorson.
I don't know that much about legal stuff, but I'm just kind of wondering if you went back to court, could the judge not rule that he has a penalty of such, the person that did it again? I mean, I'm just confused. I don't know.
Chairman Zwanzer.
Thanks. So I believe, to answer Representative Provenza's question, what we're trying to do is tie it back onto page 6, line 17. So it's going to be the same misdemeanor punishment of 6 months or $750. I assume you could do contempt, but what we're seeing in Wyoming is we have a lot of these cases we've had, at least in my county, have been people moving from other states who had a judge say no more dogs, and so they just left that state and moved to our state and have dogs. So other states certainly do have these provisions, and I think that would prevent it. But the people who tend to get prosecuted, as soon as they get prosecuted in one jurisdiction, they move to a different state or across the state. So maybe you could hold them in contempt, but I think that answers both questions, hopefully.
Representative Oakley.
Thank you, Mr. Chair. So also to Representative Provenza's question, saying, and I know this is said a lot with the criminal justice system, isn't there something like a mental health rather than throwing them in jail. And I can tell you, usually the intent isn't about throwing them in jail, but it is about having a law enforcement having any sort of authority. So we just heard an example of people moving. People will actually move so they can continue to have their 1,000 animals or whatever. That might be a bit of an exaggeration, but what this allows us to do is protect the animals and address the harm that is being, it's not just about the defendant and helping them, but again, we're talking about animal cruelty. And without it, what I notice here, and this also goes to Representative Larson's question, which is what I'm trying to address here is it says a judge can do that, but without another provision, I can't just take a court order and even a law enforcement officer, an old JNS, and just haul somebody into court. There's no connection with enforcement. So Representative Swanister said it's possible you could take them for contempt of court of that violation of that court order. But the question would be, if it was let's say it was a 6-month misdemeanor charge 5 years ago, who's to say that that's still a standing order? But it's possible, and then you could do contempt of court. But this basically gives the authority for law enforcement to address the problem. And not only are you, just let me throw this out there, protecting animals, these end up being extremely costly. Vet bills in the thousands of dollars, cleanup in the thousands of dollars. Most of the time, the defendant does not pay that. And then they continue the behavior. And it can be very frustrating for law enforcement in the community and for veterinarians. So this adds an enforcement provision, a way to address it if they don't stop the behavior, again, after a conviction for animal cruelty.
All right, committee. So we are 16 minutes past the hour. We're in committee. The whole has reconvened, and there's just a couple of bills into the committee of the whole. We can continue just updating the committee. We can continue our discussion on this amendment. We still have Chairman Swanister's amendment as well. My preference would be not to lay the bill over, but to finish it out before we go back. So I would just ask the committee, Chairman Swanister, are you still bringing your amendment? What is your thought?
If we do question on this amendment, Mr. Chairman, and then we can vote on the bill, I can do a committee of the whole, no problem.
Okay. All right. Representative Craigo, are you almost ready to vote?
Mr. Chairman, I just wanted to point out, I have another issue that I'd like to address in the bill, and that might take a little while.
Okay.
So I just wanted to throw that out there. I sort of mentioned it earlier, and it may not be an amendment. I'll propose an amendment, but I would like to have the discussion with everybody and get everybody's thoughts on this. I have one more issue, one more wordsmithing issue within the statute that I did not include in the original amendment because I'm not super clear on what we need to do, but I feel like we need to do something.
And you want to, and just so you know, Representative Craigo, you can bring that amendment as a committee of the whole committee of the whole second reading, third reading amendment, but you want to make the amendment here in the committee?
Well, thank you, Mr. Chairman. I'd prefer just to get everybody's thoughts and insight, I guess, rather than just throw it out on the floor. I mean, I enjoy the discussion we all have, and I think there's a bunch of really thoughtful minds here that I think would be super beneficial before we bring it to the floor. But I'm willing to do whatever the chair would like, and so I can do it that way, and I can call up everybody on the committee and visit with them individually too before I do it, which would be fine. I just had one more thought, and we did not include it it would have been included in my second amendment, and I didn't because I just think I need a little more work on it. So
the committee of the whole is probably happy that our thoughtful minds are absent from its discussion right now. Let's do this because I have to be sensitive to time. And I do agree with everything you said, Representative Craigo, and I would prefer to flesh it out amongst our committee, of course. But let's dispose of the amendment that we have in front of us, decide what we want to do with it. Then, if you would, Representative Craigo, why don't you put together your thoughts in an email and get that out to the whole committee, and so we can maybe do some email correspondence, and we'll figure out what we want to do on it. If maybe you'll pick up a couple of members that want to co-sponsor it with you, maybe we'll all still support it, and then we'll tack on as many co-sponsors as we can. So from a strategy standpoint, that wouldn't be uncommon that you may see an amendment with numerous members from a committee, and it helps the body to understand, oh, that's really a committee amendment. Particularly, it happens a lot in appropriations. You'll see the entire appropriations committee on a single budget amendment, and it's a good indicator that they supported it, that just came later in the process. So there's still a way to get, I think, where you want to get and have the discussion you want to have, but I do want to get you back to committee the whole. So hopefully that will work for you, Representative Craigo. Okay. All right. Any further discussion on this amendment? Discussion on the amendment, question on the amendment being called. All those in favor of the amendment signify by raising your hand. 3. All those opposed. 4, 5. The amendment fails. Representative Oakley, you can always bring the amendment back on the floor through the various things we talked about. You get 3 readings to do that if you so desire. Okay, committee, any additional discussion on the bill? Anyone want to make any points before your vote? Anything else you want to discuss? You're ready to vote?
Question.
All right, question being called. Danielle, will you please call the vote?
Roll call vote on Senate File 26.
And Danielle, this happened earlier. Your mic might be a little too far away from you.
Oh, sure. Give me just 1 second, Mr. Chairman. Is that any better for you, Mr. Chairman?
Much better. Now we hear you.
Excellent, thank you. This is a roll call vote on Senate File 26. Representative Craigo.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams.
Aye.
Representative Washut.
Aye.
Representative Yin.
Aye.
Representative Zwanitzer.
Aye.
Chairman Olson.
Hi.
You have 9 ayes on that bill.
All right. Good job, Judiciary Quasi-Agriculture Committee. Representative Larson.
Mr. Chairman, that bill was, with all the amendments, is pretty tough to follow. Is there any way we could come up with something we could follow on the floor?
Chairman's one answer.
Mr. Chairman, if you want me to floor manage the bill, I will take great care to explain the standing committee amendment and see if, I don't think it's quite what we call enrolling, where we would have to pass out something, but I think if I can structure it right, I may even send out a letter to the legislature, to the House, and that might help too.
Okay. Yeah, I was going to hand it over to Chairman Zwanitzer to floor manage. And in terms of the standing committee amendment, you can dispose of that. You can do that how you wish, Chairman Zwanitzer. You can tag team with Representative Craigo. Maybe a little handout if we could come up with something might be helpful. I mean, I'm sure our colleagues from agriculture are going to come in and help explain as well that, what the bill looked like and what's not being changed and what we are changing. So I do think that will help, but it's a pretty substantial bill and then a pretty substantial amendment. So I agree. Let's, I'll leave it up to Chairman Zwanitzer and Representative Craigo if you want to come up with any type of handout that you can email around. If not, you guys, we get it out there and we'll figure out what the discussion looks like, and hopefully we don't lose it on the committee of the whole. And then on a subsequent amendment, we can come back with some type of handout if it gets real herky jerky. All right. Sounds good. Committee, anything else? Oh, the other bill, anyone have a burning desire to floor manage the first Senate file for us? Oh, Vice Chairman Washit. Thank you. I should have let you know in advance so you could take good notes. All right, committee, anything else? All right, with that, we'll see you in the committee of the whole. The committee is adjourned.